of a written statement of its observations and submissions on the preliminary objections raised by Kenya. Somalia filed such a statement within the time limit so prescribed, and the case thus became ready for hearing in respect of the preliminary objections. Pursuant to Article 53, paragraph 2 of its rules, the Court decided, after ascertaining the views of the parties, that copies of the pleadings and documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, in accordance with the Court's practice, all of these documents will be placed on the Court's website from today. I note the presence at the hearings of the agents, counsel and advocates of the two parties. In accordance with the arrangements on the organization of the procedure decided by the Court, the hearings will comprise a first and second round of oral argument. The first round of oral argument will open today and close tomorrow, on Tuesday, 20 September. Each party will have one session of 3 hours. The second round of our argument will begin on Wednesday, 21st September, and conclude on Friday, 23rd September. Each party will have one session of 1.5 hours. I now give the floor to the Honorable Mr. Mugai, Agent of the Republic of Kenya. Your Excellency, you have the floor.
Mr. President, distinguished members of the Court, it is my very great honor and privilege to appear before you as Agent of the Republic of Kenya in this hearing of preliminary objections. My name is Githu Muigai, and I serve as the Attorney General of Kenya. I am accompanied today by Her Excellency Mrs. Rose McKenna Mushiri, Co-Agent and Ambassador of Kenya to the Kingdom of the Netherlands, by Ms. Justa Nkoroi, Director of the International Boundaries Office of Kenya, and by other officials and representatives of my government. We greet you and express our deepest respect and consideration for the Court. I also take this opportunity to greet the Honorable Agent of the Federal Republic of Somalia and other members of the Somali delegation. We extend to you our neighborly friendship and goodwill. Mr. President, this is the first time that Kenya appears before the International Court of Justice. It is important an occasion for my country. Kenya holds this institution, the principal judicial organ of the United Nations, in the highest regard. Kenya's position that this court is not competent in the present case is not a retreat from its respect for international law. On the contrary, it is a reflection of Kenya's insistence that agreements must be performed in good faith. As is clear from its optional clause declaration under Article 36(2) of the statute, Kenya has not consented to the court's jurisdiction over disputes in regard to which it has agreed to another method of settlement. In this case, it is the Memorandum of Understanding, the MOU of 7th April 2009, that sets out the agreed procedure for settlements of the dispute that Somalia has brought before the court. Furthermore, Part 15 of the 1982 UN Convention on the Law of the Sea, which binds Somalia and Kenya alike, is yet another agreed procedure for the settlement of the dispute. Kenya's history is shaped profoundly by the belief that respect for international commitments is the basis for peaceful and friendly relations. Kenya gained independence from colonial rule on the 12th of December 1963 The day after its independence, Kenya became a founding member of the Organization of African Unity, the predecessor of the African Union. 2 days later, Kenya became a member of the United Nations. In 1967, it became a founding member of the East Africa Community. It was in 1965, shortly after its independence, that Kenya made a declaration under Article 36(2) of the Court's statute, recognizing its compulsory jurisdiction subject to reservations. Today, Kenya is a stable multi-ethnic democracy, an increasingly prosperous nation recognized for its leadership role both at the United Nations and the African Union. This includes Kenya's long-standing support for the government and the people of Somalia. Since the collapse of the Somali state in 1991, Kenya has provided humanitarian relief for almost 500,000 Somali refugees. Kenya also provided a safe haven in Nairobi for the Somali Transitional Federal Government from its establishment in 2004 until improved security conditions allowed for its gradual return in the beginning of 2007. In fact, Kenya played a decisive role in defeating al-Shabaab forces and capturing Mogadishu. It has made significant contributions, both the civilian and military components of the UN-mandated African Union mission in Somalia. Hundreds of Kenyan soldiers have lost their lives defending the Somali government. They and their families have paid the ultimate price so that our neighbors can live in peace. What is more, hundreds of Kenyan civilians have been the victims of al-Shabaab terrorist attacks in retaliation for Kenya's support of the Somali government. Just to give one example, in April 2015, 150 students were killed and 700 held hostage at Garissa University College. The United Nations and the African Union have recognized Kenya's huge and extraordinary sacrifice. Mr. President, distinguished members of the court, it is against this background that Somalia's accusation of bad faith against Kenya should be assessed. Somalia would have the court believe that during all these years, Kenya has been scheming to take advantage of its neighbor to steal its sea and oil. Such accusations are absurd and they are hurtful. They are unfair and disrespectful to a government and people that have sacrificed so much in support of Somalia. Mr. President, it is common ground that Kenya has exercised uncontested jurisdiction in this maritime area since it proclaimed its exclusive economic zone in 1979. In fact, the EEZ boundary was an extension of the territorial sea boundary that reflected prior colonial practice. During the course of this dispute, Kenya has caused no prejudice to Somalia's legal rights. As a matter of fact, Kenya limited itself to transitory exploratory activities, even those are now suspended. It is not in dispute either that Kenya faces a very real security threat by reason of al-Shabaab weapons smuggling and infiltration at sea. Nor is it in dispute that Somalia has no maritime enforcement capacity and will have none in the foreseeable future. Indeed, for the past several years, the Kenyan Navy has incurred significant costs in patrolling this maritime area under an African Union mandate with the endorsement of the United Nations Security Council. It must continue to do so for the foreseeable future. In order to allay any concerns that Somalia may still have, Kenya has, by a diplomatic note dated the 25th of May 2016, invited Somalia to enter into provisional arrangements of a practical nature, pending an agreement on the maritime boundary in accordance with Article 74, Sub-Article 3, and Article 83, Sub-Article 3 of the UN Convention of the Law of the Sea. Somalia's response recognizes that Kenya's measures are consistent with all obligations under the Convention. This maritime boundary delimitation is not as straightforward as Somalia suggests. A full and final settlement will have to contain several important elements that call for a negotiated agreement, that call for a recognition of the long-standing modus vivendi between the parties, that call for time until Somalia achieves greater stability. That is exactly what the MOU provides, a gradual negotiated settlement. To say that the MOU is irrelevant because two technical level meetings 4 months apart in 2014 have exhausted negotiation is in plain contradiction with both Somalia's obligations under the MOU and the obvious reality of the situation. Mr. President, distinguished members of the court, there is a Swahili proverb that the person who helps you in need is truly your friend. Kenya has been a true friend of Somalia throughout its years of need. Kenya maintains a friend of Somalia. All that Kenya asserts is that the agreements must be performed in good faith. Somalia cannot repudiate its obligations and then portray itself as a victim of Kenya. The MOU sets out the agreed procedure for settling this dispute. It must be followed, and in the very unlikely event that its procedure fails to produce a negotiated settlement, then Part 15 procedures under the UN Convention of the Law of the Sea would then come into operation. That too is an agreed procedure other than recourse to the court. That too falls squarely within Kenya's reservation to the court's jurisdiction. These are the agreed methods of settlement, and we respectfully submit that the court declare that Somalia's case falls outside its jurisdiction. Mr. President, Kenya's first round of oral pleadings this morning will commence with an opening speech by Professor Payam, who will set forth an outline of Kenya's case. He will be followed by Karim Khan QC, who will address the legal validity of the MOU. Following the break, Professor Matthias Fatou will present the terms of the MOU under the law of treaties and explain why it constitutes an agreed-on method of settlement of the maritime dispute. Ambassador McKenna Mushiri will then explain why the parties have not exhausted negotiations. She will be followed by Professor Alan Boyle, who will address why, in addition to the MOU, the procedures under the UN Law of the Sea Convention are the applicable method of settlement of the maritime boundary dispute. And finally, Professor Law QC will conclude Kenya's first round of oral pleadings by explaining why both the MOU and the UN Law of the Sea Convention procedures fall squarely within Kenya's reservation and thus exclude the court's jurisdiction. Mr. President, distinguished members of the court, that concludes the agent's remarks, and I would now like you to please call Professor Payam to the podium, and I thank you.
Merci, Excellence. Je donne la parole à Monsieur le professeur Akavan.
Mr. President, distinguished members of the court, I'm honored to appear before you today on behalf of Kenya. I will be providing an overview of Kenya's preliminary objections. My colleagues will then elaborate the specific issues in turn. The only question before the court is whether the maritime boundary dispute between Kenya and Somalia falls within its jurisdiction. Kenya respectfully submits that it does not. Kenya's optional clause declaration, which you may find at tab 4 of your folders, categorically excludes disputes in regard to which the parties to the dispute have agreed or shall agree to have recourse to some other method or methods of settlement. This is exactly the kind of reservation the court had in mind in the land and maritime boundary case. It observed that states remain free to insert into their optional declaration accepting the compulsory jurisdiction of the court a reservation excluding from the latter those disputes for which the parties involved have agreed or subsequently agree to resort to an alternative method of peaceful settlement. The meaning of Kenya's reservation is absolutely clear. In certain phosphate lands in Nauru, the court interpreted an identical reservation in Australia's optional clause declaration. It held that it applies to any agreed procedure other than recourse to the court. The agreed procedure, however, does not have to specifically exclude the court. It excludes jurisdiction simply because it falls within the reservation. A distinguished publicist explains, in regard to the United Kingdom's identical reservation, that it is an application of the relationship between parallel commitments to dispute settlement, giving priority to the specific over the general. Put differently, the reservation covers any procedural lex specialis applicable to the dispute. The court has confirmed that optional clause reservations should be interpreted in a manner compatible with the effect sought by the reserving state. The clear effect sought by Kenya is to exclude all disputes with an agreed procedure other than recourse to the court. The court must give strict effect to that intention in determining the scope of its jurisdiction. In regard to the maritime boundary dispute between Kenya and Somalia, there are in fact two agreed procedures. The first is the MOU of 7 April 2009. It states clearly that the parties shall agree on delimitation by negotiation and that they shall do so after review of the respective submissions by the Commission on the Limits of the Continental Shelf. The second is the UNCLOS Part 15 procedures, which makes specific provision for delimitation disputes. These two agreed procedures, whether separately or in combination, fall squarely within Kenya's reservation. They both categorically exclude the court's jurisdiction. The case before you is as simple as that. Somalia has pursued a strategy that is best described as MOU avoidance. It has done everything possible to rid itself of what it apparently considers to be a legal obstacle to its new strategy on maritime delimitation. First, shortly before filing its application in August 2014, Somalia submitted a letter dated 4 February 2014 to the UN Secretary General. It withdrew its prior consent to Kenya's CLCS submission. It maintained that the no objection obligation was not legally binding because the MOU was null and void. In particular, Somalia alleged that Minister Warsame, who signed the MOU for Somalia, did not have full powers. That allegation was not true. In fact, Somalia has now produced the minister's letter of authorization in its written statement. That false argument has now been abandoned by Somalia. Second, Somalia withdrew its CLCS objection just 1 week before its memorial was submitted, and then tried to downplay the legal effect of the MOU in its memorial. It suggested that its legal validity was uncertain. It set forth all the paragraphs of the MOU, with a notable exception of the final paragraph, which stated that it entered into force upon signature. It also ignored the significance of the registration and publication of the MOU in accordance with Article 102 of the UN Charter. Somalia further ignored the fact that its own Prime Minister had specifically confirmed its validity in writing to the UN on at least 2 occasions. Third, Somalia still complains in its written statement that the MOU required parliamentary ratification under its transitional federal charter. But it does not argue that the MOU is invalid because of an alleged defect under Somalia's internal law. What is more significant is that the 1 August 2009 parliamentary vote rejecting the MOU in fact makes no mention of the transitional federal charter. Kenya has produced the verbatim record of those deliberations. Somalia does not dispute its authenticity. Whether in fact or in law, this argument has no merit whatsoever. Somalia's conduct has been such that even Norway, which was in fact supporting Somalia with its CLCS submission and establishment of an EEZ, complained to the UN that Somalia's actions were creating doubt as to its capability to enter into legally binding international commitments. Norway expressed its hope that it would be possible to find a way to affirm the legally binding nature of the MOU. Now that Kenya has invoked the MOU before the court, Somalia appreciates that it cannot credibly challenge its validity. Instead, it has now shifted its MOU avoidance strategy by arguing that the penultimate paragraph on the method of settlement is without any legal effect. Somalia's new theory is that irrespective of the MOU's legal validity, that particular paragraph is merely spare and descriptive, that it should simply be ignored by the court. The text of that paragraph, however, is absolutely clear. It is at tab 5 of your folders. It reads as follows: the delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles, shall be agreed between the 2 coastal states on the basis of international law after the Commission has concluded its examination of the separate submissions made by each of the 2 coastal states and made its recommendations to the 2 coastal states concerning the establishment of the outer limits of the continental shelf beyond 200 nautical miles. First, the terms refer in the plural to delimitation of maritime boundaries in the areas under dispute. Then it specifically clarifies that this is including the delimitation of the continental shelf beyond 200 nautical miles. Thus, its scope is clearly not limited to the outer shelf, as Somalia claims. It indicates the exact opposite. The MOU was prepared under the supervision of the Norwegian ambassador Longva, a distinguished international jurist who sadly passed away in 2013. It was drafted precisely and meticulously. It refers to all areas in dispute. Second, the terms provide that delimitation shall be agreed between the 2 coastal states on the basis of international law. The term is shall. It is not should. It is a legal undertaking, a binding obligation, not merely to negotiate in good faith, but to do so with a view to concluding an agreement. In North Sea Continental Shelf, which is at tab 6 of your folders, the court interpreted the less exacting terms shall be determined by agreement under Article 6 of the 1958 Convention on the Continental Shelf as follows. The parties are under an obligation to enter into negotiations with a view to arriving at an agreement, and not merely to go through a formal process of negotiation as a sort of prior condition for the automatic application of a certain method of delimitation in the absence of agreement. They are under an obligation so to conduct themselves that the negotiations are meaningful, which will not be the case when either of them insists upon its own position without contemplating any modification of it. In Gabčíkovo Nagimaros, the court confirmed that such an obligation requires the parties to find an agreed solution within the cooperative context of the applicable treaty. Third, the terms of the MOU provide that a delimitation agreement shall be completed after the Commission has concluded its examination of the separate submissions made by each of the two coastal states and made its recommendations to the two coastal states concerning the establishment of the outer limits of the continental shelf beyond 200 miles. Contrary to what Somalia claims, this does not mean that the parties cannot negotiate prior to CLCS review. That would be absurd. The parties may negotiate prior to CLCS recommendations, but they may finalize an agreement only after delimitation of the outer limits of the shelf. It is remarkable that Somalia does not produce the text of this paragraph of the MOU until page 75 of its written statement. It spends the vast majority of its pleading arguing that the MOU was only concerned with delineation of the outer shelf and nothing else. By Somalia's inverted logic, this exclusive purpose renders the impugned paragraph redundant. The actual text of the MOU somehow evaporates in the intense light of a contrived context. That cannot be right. The court has made it clear that interpretation must be based above all upon the text. In other words, if the relevant words in their natural and ordinary meaning make sense in their context, that is an end of the matter. There is no ambiguity here as to the meaning of shall be agreed after the Commission has concluded its examination and made its recommendations. That is the end of the matter. No amount of creative lawyering can change its obvious meaning. But let us imagine that there was some ambiguity in the text, that the paragraph was in fact vague and capable of competing interpretations. What would happen then? Would the ambiguity be resolved by depriving the text of legal effect? Surely not. Somalia curiously invokes the effet utile principle in an attempt to nullify Kenya's reservation, but it completely disregards that same principle in respect of the MOU. The principle of effectiveness is clear. If more than one interpretation is possible, the preference should be given to the one which does not have as an effect to wholly or partially deprive a term, sentence, or article of any legal meaning and thus of any practical impact. The phrase shall be agreed after CLCS review is neither spare nor descriptive. It must be given legal effect. It is a binding obligation. It should be emphasized that Somalia admits that the penultimate paragraph does in fact prescribe a method of settlement. Its only contention is that negotiations are one among other possible methods of dispute settlement, and that the MOU does not specifically exclude recourse to the court. But that argument is inapposite. First, if the parties agree to a method of settlement, then they must perform their obligations in good faith. That alone renders Somalia's case inadmissible. Second, even if this paragraph of the MOU does not exclude recourse to the court, it still falls within Kenya's reservation. All that is required is an agreed procedure other than recourse to the court. There is no additional requirement that it specifically exclude the court. If the parties had to agree to exclude the court, then Kenya's reservation would be redundant. Somalia goes to great lengths to suggest that if the court does not exercise jurisdiction, the parties will never be able to conclude an agreement on delimitation. It maintains that they have exhausted negotiations based on just 2 technical meetings 4 months apart that were held immediately prior to the filing of Somalia's application in 2014. Somalia's theory of deadlock does not withstand scrutiny. First, under the MOU, the parties agreed to conclude a delimitation agreement only after CLCS review. This is a precondition to move to the next stage of the agreed procedure. It is a binding obligation. Somalia claims that this requirement is illogical because it will be a decade before the CLCS considers its submission. But it is not unusual for boundary agreements to be finalized over several years. Furthermore, Somalia's submission is likely to be considered earlier than anticipated. It should be recalled that Kenya's submission was initially scheduled for 2022, but came in the queue for 2014, 8 years earlier. Somalia may similarly jump the queue. There are objections to several earlier submissions, and the CLCS is expediting its working procedures. Contrary to Somalia's suggestions, CLCS review is not an insurmountable obstacle. In any case, the parties were mindful of the time required for CLCS review when they concluded the MOU. Somalia cannot now argue that this condition would deprive the MOU of its effect. Second, the obligation to negotiate in good faith with a view to concluding an agreement is an exacting obligation. It is not satisfied by merely convening 2 technical meetings 4 months apart. Maritime boundary agreements are a time-consuming process. What parties cannot agree on today, they may agree on tomorrow. The circumstances are even more complex in the context of bilateral relations between the parties. Somalia is still in the midst of a fragile post-conflict transition. Kenya has publicly noted its concern that maritime security in the area continues to pose an existential threat to Kenya and the other countries within the region. This includes continued maritime enforcement against al-Shabaab terrorists in the disputed maritime areas where Kenya has exercised prolonged and uncontested jurisdiction. Third, Kenya called for the negotiations in 2014 because of Somalia's breach and repudiation of the MOU. Somalia had objected to Kenya's CLCS submission in February 2014. The parties held their first meeting in March 2014. Kenya proposed to discuss the MOU. Somalia refused. Kenya wished to discuss the matter again at the second meeting in July 2014. Again, Somalia refused. This was hardly a proper negotiation of the maritime boundary. Fourth, it is apparent that by 2014, Somalia had already prepared to file its application before the court. The proceedings were initiated in August 2014, in the same week that the parties had scheduled their third meeting. As the court has emphasized, the parties cannot merely go through a formal process of negotiation as a sort of prior condition for the automatic application of a certain method of delimitation in the absence of agreements. There must be meaningful negotiations, not rigid insistence on a particular method of delimitation, which is exactly what Somalia did. In fact, on 6 June 2013, the Somali Council of Ministers had rejected any discussions on maritime demarcation or limitations on the continental shelf with Kenya. It would appear that Somalia was going through the motions just to get before the court. Against this background, it cannot be said that the parties have exhausted negotiations. Mr. President, even if the parties had never concluded the MOU, the dispute would still fall outside of the court's jurisdiction. This case concerns UNCLOS, and the agreed procedure for delimitation under UNCLOS is Part 15. Apart from the MOU, Part 15 is the applicable procedural lex specialis between Kenya and Somalia. It, too, falls squarely within Kenya's reservation. Somalia's only argument is that the court's jurisdiction applies in lieu of Part 15 procedures because the matching optional clause declarations of Kenya and Somalia constitute an agreement within the meaning of Article 282. This argument is fundamentally flawed. The two declarations are clearly not matching. Kenya has a reservation concerning agreed procedures other than the court. Somalia does not. Part 15 is clearly an agreed procedure other than the court. It falls squarely within Kenya's reservation. It is remarkable that Somalia argues, in fact, that Part 15 is incorporated into the MOU. It maintains that the term shall be agreed merely restates the basic principle articulated in Articles 74.1 and 83.1 of UNCLOS, according to which the delimitation of maritime boundaries shall be effected by agreement. Paragraph 2 of those two provisions provides in identical terms that if no agreement can be reached within a reasonable period of time, the states concerned shall resort to the procedures provided for in Part 15. If Somalia's interpretation of the MOU is correct, then Part 15 would apply to the exclusion of the court's jurisdiction. Nonetheless, Article 280 of Part 15 still provides that the parties may agree to settle a dispute by any peaceful means of their own choice. Thus, the MOU applies even under Part 15. In fact, Article 281.1 clarifies that the procedures apply only where no settlement has been reached by recourse to such means, and the agreement between the parties does not exclude any further procedure. Furthermore, Article 281.2 specifically provides that if the parties have also agreed on a time limit, Paragraph 1 applies only upon the expiration of that time limit. In this case, CLCS review is a time limit. Part 15 is not applicable prior to its expiration. Even after CLCS review, the next step under Part 15 is to exchange views regarding its settlement by negotiation or other peaceful means in accordance with Article 283. Somalia has invoked the optional clause declarations under Article 36.2 of the court's statute as the sole basis for jurisdiction. Neither Kenya nor Somalia has made a declaration under Article 287.1b of Part 15 recognizing the court as the method of settlement. Thus, the UNCLOS procedures are a method of settlement other than recourse to the court. They exclude the court's jurisdiction. Mr. President, distinguished members of the court, as I've explained, Kenya's preliminary objections are based on the straightforward application of its reservation in light of both the MOU and UNCLOS Part 15. The court needs only to apply basic principles of treaty interconclusion that this dispute falls outside of its jurisdiction. Nonetheless, Kenya will briefly address some of the unfortunate accusations of bad faith that have been made by Somalia. Presumably, these are intended to persuade the court to decide in Somalia's favor in disregard of the applicable law. In particular, Somalia has gone to considerable lengths to suggest that Kenya is a bad neighbor that has suddenly claimed an unjust maritime boundary in 2005 and is now seeking to establish a fait accompli so it can immediately exploit offshore oil resources in the disputed areas. This is simply not true. It does not even remotely reflect reality. First, the maritime boundary at the parallel of latitude in the EEZ was established in 1979 and not in 2005, as Somalia suggests. It was in 1979 that Kenya first proclaimed its EEZ and began exercising jurisdiction based on that boundary. The text of the presidential proclamation of 28 February 1979 is set out as Annex 19 to Somalia's memorial. Prior to the MOU in 2009, Somalia never disputed this boundary. In fact, the EEZ boundary was the extension of an uncontested Anglo-Italian territorial sea boundary from the colonial period. Second, Kenya's exploratory activities in the disputed areas have been only of a transitory character. They are well within the range of activities that, as the court indicated in the Aegean Sea case, cause no irreparable prejudice to the rights of other states. In fact, even these transitory activities have been temporarily suspended, and Kenya has invited Somalia to negotiate provisional arrangements of a practical nature pursuant to Articles 74.3 and 83.3 of UNCLOS. As the agent indicated, Somalia now recognizes that Kenya's conduct is consistent with all obligations under the Convention. There is no imminent threat to its interests. Oil has yet to be discovered, let alone exploited. Even if it were discovered tomorrow, production would be at least a decade away. In this light, there is no basis for Somalia's alarmist accusations against Kenya, and most certainly no justification for the accusation that it is an unjust nation taking advantage of its neighbor. This is especially unbecoming given the extraordinary sacrifices that Kenya has made in solidarity with the government and people of Somalia. Mr. President, distinguished members of the court, the 2009 MOU opened the way for future cooperation. It was one of the first agreements between Kenya and the new Somali government. Somalia's breach and repudiation of the MOU, its objection to Kenya's CLCS submission, its unwillingness to negotiate in good faith, its initiation of proceedings before the court in disregard of the agreed procedure, its false accusations and alarmist tone, these will not resolve the complex issues that must be negotiated between the parties during Somalia's still fragile transition. Disregard for international commitments will do nothing to further friendly relations among these two neighboring African nations. The MOU and Part 15 are the agreed procedures for settlement of the maritime dispute between the parties. They both fall squarely within Kenya's reservation, and thus the dispute is outside of the court's jurisdiction. Mr. President, distinguished members of the court, that concludes my presentation. I would now ask that you invite Mr. Karim Khan, QC, to the podium.
Merci, Monsieur le Professeur. Je donne à présent la parole à Monsieur Karim Khan.
Mr. President, distinguished members of the court, it is an honour to appear before you on behalf of the Republic of Kenya. I will address the legal validity of the Memorandum of Understanding, MOU, and in particular Somalia's attempts to declare the MOU null and void in 2014, just a few months before it filed its application before the court. Somalia has now abandoned its claim of nullity, but seeks instead to deprive the terms of the MOU of any legal effect. Mr. President, the MOU was initiated by Somalia and drafted and reviewed pursuant to the advice of a respected Norwegian diplomat. Prior to its signature, the MOU was approved by the President of Somalia, by the Prime Minister of Somalia, and by Somalia's Council of Ministers. The references to the evidence will appear in the footnotes to the transcripts of my speech. The Minister of National Planning and International Cooperation was authorized by the Prime Minister to sign the MOU on behalf of the Somali government. On the 7th of April 2009, he and the Kenyan Minister of Foreign Affairs, duly authorized by their respective governments, signed the MOU at a formal ceremony in Nairobi. The MOU expressly stated that it would enter into force upon its signature. The subsequent conduct of the parties was entirely consistent with the validity of the MOU. On the 8th of April 2009, the day after the signing ceremony, the Somali Prime Minister expressly confirmed its validity and indeed reproduced the MOU in full and enclosed a copy of the signed instrument in Somalia's submission to the CLCS. 2 months later, on the 11th of June 2009, in accordance with Article 102 of the UN Charter, the MOU was formally registered with the UN Secretariat. A certificate of registration was issued by the UN Secretariat, and the MOU was published in the UN Treaty Series and in the Law of the Sea Bulletin. It is evident from UN rules that a treaty cannot be registered unless it is in force. The MOU was subsequently confirmed in a letter by the Somali Prime Minister to the United Nations Secretary General on the 19th of August 2009, after the Somali Parliament's vote on the 1st of August 2009 to reject the MOU. In that letter, Somalia specifically referred to and reproduced the relevant paragraph of the MOU that it now contends to be without legal effect. Mr. President, Somalia included the MOU in Annex 6 to its memorial with a cover page stating entry into force 7th of April 2009 by signature. Somalia chose the following title for the annex: MOU entered into force 7th of April 2009. In Volume 2 of Somalia's memorial, the MOU is included in a section of the annexes entitled Treaties and agreements. There can be no doubt that Somalia now admits that the MOU is legally binding and that the provision on the method of dispute settlement is also legally binding. Mr. President, I now turn to Somalia's changing case on the validity of the MOU. It is significant that Somalia did not deny that the MOU is a treaty. Kenya agrees. The MOU is indeed a treaty. It is an agreement concluded in writing and governed by international law. And as such, the principle Pacta sunt servanda applies. Prior to these proceedings, in its 4th of February 2014 letter to the United Nations Secretary General, objecting to Kenya's CLCS submission, Somalia claimed that the MOU was null and void. It requested, unsuccessfully, the withdrawal of the MOU from the new UN Register of Treaties. Somalia argued that the minister who signed the treaty did not have full powers. That contention was false. Somalia now admits that its minister did in fact have full powers. Indeed, it has now produced the letter of authorization from the Somali Prime Minister in its written pleadings. Somalia's argument on nullity has been rightfully abandoned. Somalia also claimed that the minister had orally communicated the requirement of ratification to Kenya at the time of signature. There is no record of any such statement. The MOU expressly provides that it shall enter into force upon signature. It is remarkable that Somalia's memorial reproduced every paragraph of the MOU except that provision. Somalia now admits that the MOU entered into force upon signature. The previous contention that ratification was necessary before the MOU entered into force has been similarly abandoned. Instead, Somalia now asserts that although the MOU did in fact enter into force upon signature, it was contrary to Somali internal law. It claims that the MOU was rejected by a parliamentary vote on the 1st of August 2009 because it was inconsistent with the Somali Transitional Federal Charter, which it asserts required ratification of all international agreements. That argument is both irrelevant and wrong as a matter of fact and law. Internal law, of course, is not a ground for violation of international obligations, as is made clear by Article 27 of the Vienna Convention of the Law of Treaties. Somalia, in fact, does not claim that the MOU is invalid as a result of alleged inconsistency with the Transitional Federal Charter. It does not invoke the narrow exception in Article 46 of the Vienna Convention, the criteria for which would not have been satisfied in any event. Norway referred to Article 46 in its 17th of August 2011 letter to the UN Secretariat and rejected its application. It stated that, and I quote, "Norway considers both Somalia and Kenya to remain bound by the provisions of the MOU." As noted by the tribunal in the case concerning the arbitral award of the 31st of July 1989, Guinea-Bissau and Senegal, and I quote, "As for the practice of international courts and arbitral tribunals, there was no precedent of a treaty being declared null and void because one of the contracting states had violated its own internal laws in signing it. But what is most significant is that the Somali Parliament never invoked the Transitional Federal Charter in its vote on the MOU. Kenya has produced the verbatim record of the debate in the Somali Parliament. Somalia does not dispute either the authenticity or the accuracy of these records. Nothing whatsoever in that debate refers to the Transitional Federal Charter. Mr. President, it's important to note that those parliamentary deliberations were in any event based upon deliberate disinformation. This deliberate disinformation was apparently spread by the terrorist group Al-Shabaab, who claimed that by concluding the MOU, the Somali government was selling the sea to Kenya. It was, in the words of Somalia's own minister, Wasami, a campaign of slandering, defaming, and false accusation. It had nothing to do with the procedural requirements or any asserted provision, saying that even if it were legally valid, its provisions have no legal meaning. It argues that the carefully drafted terms of the MOU are merely spare and descriptive. This is part of a consistent pattern by which Somalia seeks to evade its obligations under the MOU. First, Somalia objected to Kenya's CLCS submission. Now it repudiates the agreement on the method of settlement. In fact, Somalia withdrew its CLCS objection only a week before submitting its memorial. Now that it has finally complied with its obligations on the first part of the MOU, it attempts to ignore its obligations in the second part. The agreement on no objection was the first step towards finalization of a maritime boundary agreement after CLCS review. The two parts are inseparable. Finally, Somalia suggests that it had nothing to do with the drafting of the MOU, and it didn't know what it was signing. It states that, and I quote, Somalia had virtually no input in negotiating and drafting of the MOU, end quote. It is not in dispute that Norway prepared the draft on Somalia's behalf, and that it was drafted with precision and expertise by Ambassador Longva, a renowned Norwegian diplomat and jurist who served as the legal advisor in the Ministry of Foreign Affairs for 47 years, until his death in 2013. Every letter, every digit, every typographical error in the MOU was reviewed prior to finalization of the draft. There was nothing random about its terms. Furthermore, it is not in dispute that Somalia benefited from the opinion and approval of an eminent Somali jurist before signing the MOU. Somalia cannot claim now that the MOU was not a proper, legally binding agreement. Mr. President, Somalia has gone to great lengths in its strategy of MOU avoidance. First, it challenged the MOU's validity, arguing that Minister Vasami did not have full powers. Then it argued that there was a requirement of ratification by the Parliament. Those arguments have now been rightfully abandoned because they are entirely baseless. Now, in these proceedings, Somalia argues that the MOU is legally valid, but that its provisions are devoid of legal meaning. That cannot be right. The MOU is a legally binding agreement on the method of settlement of the maritime dispute between the parties. And as my colleague Professor Fatou will explain, its provisions must be given full legal effect. Mr. President, members of the Court, that concludes my submissions. Mr. President, I'm in your hands. I would ask that either we adjourn now and after the break, Professor Fatou continue the submissions of the Republic of Kenya, or with your leave, he can continue them now.
Merci, Monsieur Khan. Je crois que c'est le moment adéquat pour une pause de 10 minutes. L'audience est suspendue.